My name is Charles D. Viccellio. I was born in Lake Charles, Louisiana, July 8, 1933. I primarily was raised in the city of Lake Charles. I lived a little while in Texas, a little while in Shreveport, but basically from age 8 until this point, I have been a resident of Lake Charles. My family is 3 generations deep on each side. I graduated from Lake Charles High School in 1951. That was the year the school burned. The students for the school thereafter were dispersed into a couple of grade schools and in a new building that was being built on the campus. And ultimately, a brand new high school was constructed at the same site. I've often joked about how I selected college. I was fortunate to go to LSU on a number of occasions for various activities, including one stint in the first grade. And so I thought, well, I know LSU. I want to go someplace else. So a number of people from Lake Charles High that were ahead of me were at Tulane, and so I selected to go there. Started Tulane in the fall of 1951 and finished in January of 1957. At the time I was in school was the time of the Korean conflict, so everyone wanted to stay in school if they could, and since I was aware that if I did correctly I would be able to keep that scholarship through law school, I forewent getting an undergraduate degree because I would have been commissioned in the United States Army and been off to service. So I have no undergraduate degree, just an LLB degree from Tulane. I did my undergraduate work in 2.5 years and then law school in 3 years. I graduated from Tulane in January 1957. At that time, all World War II and Korean veterans were exempt from taking the bar exam. So since there were only half a dozen to a dozen people who had not participated in one of those conflicts that were finishing law school, no bar exam was required. So as soon as I finished school and came home, I took my oath before my aunt, who was a notary public, and then was admitted to the bar officially in February in the now present but then old Supreme Court building. After I was admitted and came to work with the firm of Plochet and Stockwell, Uncle Sam decided he needed my services, and he called me up, and I was an RAF officer, Reserve Forces officer that served a limited time, 6 months, and then I spent my time in the reserves for 8 years, and finally was discharged as a captain. Before I went off to service, members of the firm were, at the time where I was employed, were Vance Plochet and Oliver Stockwell were the name partners, and Jimmy St. and Fred Sievert, and they asked would I come back. And of course I was delighted at the request, and I returned to practice in the fall of '57, and have basically stayed in that Warren firm till the time I retired, effective December 31st, 2013. When I first started practicing, of course, we were a small group, and you got to dibble or dabble of everything. But I quickly found that tort litigation and workers' comp were not my cup of tea, and I primarily worked as an office lawyer, and ultimately ending up primarily doing commercial real estate and industrial real estate. Along the way did utility law and did probate and a number of business formations. Lots of work dealing with commercial leasing, mortgage lending, all of which I enjoyed thoroughly. When I first started practicing, well, manual typewriters were the issue. There were few select electrics in the firm. We used a wet process copier, made mailing very heavy. we had a very limited phone system. After some analysis of the cost of dealing with copy work, I determined that then the Xerox machine was the ideal machine, cost-wise and speed-wise. And I proudly walked down and visited with the boss, Mr. Stockwell, and said, this is what we need to do. And he said to me, I really don't care whether that's the best one or not. It's the one in the ABA Journal in October I want. And fortunately, it was the Xerox, and we had the first Xerox in a law firm, and I think the fourth Xerox machine in Calcasieu Parish. And it was a humdinger. It copied 3 copies a minute. After that, of course, things have moved a lot faster. Everybody ended up with automatic typewriters, and then we had a mag card typewriter, and then we've gone to computers and complicated phone systems, and technology has just gone like 90. It has, of course, taken some of the graciousness out of the practice of law, because everybody expects everything by instant return action, and it makes it much more difficult for you to think through problems when you're required to answer instantly. When I first started to practice, the bar was a very small bar in this area. We practiced in Beauregard, Vernon, Allen, Jeff Davis, Calcasieu, of course, Cameron. But there weren't very many lawyers in most of the outlying towns. And Lake Charles had about 125 lawyers and judges. So you knew each other reasonably well, even though you might not work in the area in which some of these lawyers worked. And because you knew each other well and you rubbed elbows regularly in the courthouse, everybody was pretty much, for lack of a better term, on the up and up with each other, because they knew that when you pass this way one time, you're going to pass that way again. And so being square with one another was very important. As time has gone on, of course, we've got many, many more lawyers, and it's almost impossible for the lawyers to all know each other and have a personal relationship. And I think that affects each lawyer's feeling about what he's supposed to do for his client, without thinking in terms of the big picture of the overall relationship of the lawyer to the other members of the bar. And I have found that the practice of law became much more cutthroat, and so it was more difficult to necessarily accept what people said to you. And so everything came with the necessity of confirming it in writing. I think that's a shame, but of course it does cut down on misunderstandings. During my practice, when I first came, there were 3 divisions of court in Calcasieu Parish, which also covered Cameron Parish. The judges at that time were Mark Pickrell, Preston Savoy, and Cecil Cotrier, all of whom had extremely different personalities. The first case I tried was before Preston Savoy, and it was a subrogation suit. And Judge Savoy was perusing the Wall Street Journal during my client's testimony, to my chagrin, until a young lady who was a guest passenger in the other car said, "I told Mama to stop at the red light," at which point he sat up straight and began to listen very carefully to the testimony. So I was fortunate at that point, for the first case I tried, to win it, which is very, very beneficial to a lawyer. Judge Pickrell was just the opposite. He didn't want to hear much. He wanted it heard in a hurry. and he could sometimes be absolutely brutal to lawyers. His motto was, "It's 10 o'clock when I arrive in the courtroom." And frankly, you couldn't tell whether he was going to get there at 10:10 or 10:30. So it was necessary to get there in a hurry. Cecil Couture, to the contrary, wanted everything concluded in a hurry. So he would have his cases assigned on Mondays, which he called Monday afternoon cases, would be all the small matters that could be handled very quickly. And he would bring them up and hustle you along pretty much in a hurry, and managed to keep his docket very clear. Also serving at that time was John T. Hood, Jr., who was just the opposite. Judge Hood was a very thoughtful individual who wanted to let everybody get everything in the record that they wanted to get in the record. And so many times his cases went on and on and on. But when you got through with it, and he had rendered his opinion, which I am told by others, he wrote 3 to 5 to 6 times before it was ever released, you could pretty well be assured that justice had been done. Before they had public defenders, the members of the bar were appointed very often to represent indigent defendants. All of us had a few occasions to be appointed. Criminal law was not my forte, but when you were appointed, it was your job to do what you could do to the best of your ability. I had had the experience, not from significant trial practice, of watching my partner, Fred Sievert, together with Jim Leithhead, a member of another firm, who were appointed to defend the Wilbert Rideau, whose case went to the Louisiana Supreme Court 3 times and to the United States Supreme Court once. And I realized how much effort was required and how hard those men worked, which gave us a real example about doing that kind of work correctly. I've enjoyed the practice of law because I feel that those who practice the law vigorously, not just for the compensation, but for the good that it can do, you can feel a true sense of accomplishment for helping others. I've often said it's a wonderful way to live, because others bring you their problems and let you solve them, and along the way they compensate you. But that's not the big point. The big point is that you get to help others. You get to do things that build. And in the process, you meet many wonderful people.